Chapter 6. Swindling and Other Deceits. Article 315. Swindling. Estafa. Close and close parenthesis. Any person who shall defraud another by any of the means mentioned herein below shall be punished by first, the penalty of prison correctional in its maximum period, to prison mayor in its minimum period, if the amount of the fraud is over 2,400,000 pesos, but does not exceed 4,400,000 pesos, and if such amount exceeds the latter sum, the penalty provided in this paragraph shall be imposed in its maximum period, adding 1 year for each additional 2 million pesos. But the total penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessory penalties which may be imposed, and for the purpose of the other provisions of this code, the penalty shall be termed prison mayor or reclusion temporal, as the case may be. Second, the penalty of prison correctional in its minimum and medium periods, if the amount of the fraud is over 1,200,000 pesos, but does not exceed 2,400,000 pesos. Third, the penalty of arresto mayor in its maximum period, to prison correctional in its minimum period, if such amount is over 40,000 pesos, but does not exceed 1,200,000 pesos. Fourth, by arresto mayor in its medium and maximum periods, if such amount does not exceed 40,000 pesos, provided that in the 4 cases mentioned, the fraud be committed by any of the following means. 1. With unfaithfulness or abuse of confidence, namely, letter A, by altering the substance, quantity, or quality of anything of value which the offender shall deliver by virtue of an obligation to do so, even though such obligation be based on an immoral or illegal consideration. Letter B, by misappropriating or converting to the prejudice of another money, goods, or any other personal property received by the offender in trust or on commission, or for the administration or under any other obligation involving the duty to make delivery of or to return the same, even though such obligation be totally or partially guaranteed by a bond, or by denying having received such money, goods, or other property. Letter C, by taking undue advantage of the signature of the offended party in blank, and by writing any document above such signature in blank to the prejudice of the offended party or any third person. Number 2, by means of any of the following false pretenses or fraudulent acts executed prior to or simultaneously with the commission of fraud. Letter A, by using fictitious name or falsely pretending to possess power, influence, qualifications, property, credit, agency, business, or imaginary transactions, or by means of other similar deceits. Letter B, by altering the quality, fineness, or weight of anything pertaining to his art or business. Letter C, by pretending to have bribed any government employee without prejudice to the action for calumny which the offended party may deem proper to bring against the offender. In this case, the offender shall be punished by the maximum period of the penalty. Letter D, by post-dating a check or issuing a check in payment of an obligation when the offender had no funds in the bank, or his funds deposited therein were not sufficient to cover the amount of the check. The failure of the drawer of the check to deposit the amount necessary to cover his check within 3 days from receipt of notice from the bank, and or the payee or holder that said check has been dishonored for lack or insufficiency of funds, shall be prima facie evidence of deceit constituting false pretense or fraudulent act. And a person who shall defraud another by means of false pretenses or fraudulent acts, as defined in paragraph 2, letter D hereof, shall be punished by, first, the penalty of reclusion temporal in its maximum period, if the amount of fraud is over 4,400,000 pesos, but does not exceed 8,800,000 pesos. If the amount exceeds the latter, the penalty shall be reclusion perpetua. Second, the penalty of reclusion temporal in its minimum and medium periods if the amount of the fraud is over 2,400,000 pesos, but does not exceed 4,400,000 pesos. Third, the penalty of prison mayor in its maximum period if the amount of the fraud is over 1,200,000 pesos, but does not exceed 2,400,000 pesos. Fourth, the penalty of prison mayor in its medium period if such amount is over 40,000 pesos, but does not exceed 1,200,000 pesos. Fifth, by prison mayor in its minimum period if such amount does not exceed 40,000 pesos. Through any of the following fraudulent means: A. By inducing another by means of deceit to sign any document. B. By resorting to some fraudulent practice to ensure success in a gambling game. C. By removing, concealing, or destroying, in whole or in part, any court record, office files, document, or any other papers as amended by RA 1095, August 29, 2017. Article 316. Other forms of swindling. The penalty of arresto mayor in its minimum and medium periods, and a fine of not less than the value of the damage caused, and not more than 3 times such value, shall be imposed upon 1. Any person who, pretending to be the owner of any real property, shall convey, sell, encumber, or mortgage the same. 2. Any person who, knowing that real property is encumbered, shall dispose of the same, although such encumbrance be not recorded. 3. The owner of any personal property, who shall wrongfully take it from its lawful possessor, to the prejudice of the latter or any third person. 4. Any person who, to the prejudice of another, shall execute a fictitious contract. 5. Any person who shall accept any compensation given him under the belief that it was in payment of services rendered or labor performed by him, when in fact he did not actually perform such services or labor. 6. Any person who, while being a surety in a bond given in a criminal or civil action, without express authority from the court or before the cancellation of his bond, or before being relieved from the obligation contracted by him, shall sell, mortgage, or, in any other manner, encumber the real property or properties with which he guaranteed the fulfillment of such obligation. Article 317. Swindling a minor. Any person who, taking advantage of the inexperience or emotions or feelings of a minor to his detriment, shall induce him to assume any obligation or to give any release or execute a transfer of any property right in consideration of some loan of money, credit, or other personal property, whether the loan clearly appears in the document or is shown in any other form, shall suffer the penalty of arresto mayor and a fine of a sum ranging from 10 to 50% of the value of the obligation contracted by the minor. Article 318. Other deceits. The penalty of arresto mayor and a fine of not less than the amount of the damage caused, and not more than twice such amount, shall be imposed upon any person who shall defraud or damage another by any other deceit, nor mentioned in the preceding articles of this chapter. Any person who, for profit or gain, shall interpret dreams, make forecasts, tell fortunes, or take advantage of the credulity of the public in any other similar manner, shall suffer the penalty of arresto mayor, or a fine not exceeding 40,000 pesos, as amended by RA 10951, August 29, 2017. Chapter 7. Chattel Mortgage. Article 319. Removal, sale, or pledge of mortgage property. The penalty of arresto mayor, or a fine amounting to twice the value of the property, shall be imposed upon 1. Any person who shall knowingly remove any personal property mortgaged under the chattel mortgage law to any province or city other than the one in which it was located at the time of the execution of the mortgage, without the written consent of the mortgagee or his executors, administrators, or assigns. Number 2. Any mortgager who shall sell or pledge personal property already pledged, or any part thereof, under the terms of the chattel mortgage law, without the consent of the mortgagee, written on the back of the mortgage and noted on the record hereof, in the office of the Register of Deeds of the province where such property is located. Chapter 8. Arson and other crimes involving destructions, with an asterisk. Article 320. Destructive arson, asterisk. The penalty of reclusion perpetua to death shall be imposed upon any person who shall burn 1. One or more buildings or edifices consequent to one single act of burning, or as a result of simultaneous burnings, or committed on several or different occasions. Number 2. Any building of public or private ownership devoted to the public in general, or where people usually gather or congregate for a definite purpose, such as but not limited to official governmental function, or business, private transaction, commerce, trade, workshop, meetings and conferences, or merely incidental to a definite purpose, such as but not limited to hotels, motels, transient dwellings, public conveyance, or stops or terminals, regardless of whether the offender had knowledge that there are persons in said building or edifice at the time it is set on fire, and regardless also of whether the building is actually inhabited or not. Number 3. Any train or locomotive, ship or vessel, airship or airplane devoted to transportation or conveyance, or for public use, entertainment, or leisure. Number 4. Any building, factory, warehouse installation, and any appurtenance thereto, which are devoted to the service of public utilities. Number 5. Any building, the burning of which is for the purpose of concealing or destroying evidence of another violation of law, or for the purpose of concealing bankruptcy or defrauding creditors, or to collect from insurance. Irrespective of the application of the above enumerated qualifying circumstances, the penalty of reclusion perpetua to death shall likewise be imposed when the arson is perpetrated or committed by 2 or more persons, or by a group of persons, regardless of whether their purpose is merely to burn or destroy the building, or the burning merely constitutes an overt act in the commission of another violation of law. The penalty of reclusion perpetua to death shall also be imposed upon any person who shall burn 1. Any arsenal, shipyard, storehouse, or military powder, or fireworks factory, ordnance, storehouse, archives, or general museum of the government. Number 2. In an inhabited place, any storehouse or factory of inflammable or explosive materials. If as a consequence of the commission of any of the acts penalized under this article, death results, the mandatory penalty of death shall be imposed, as amended by R.A. 7659, December 13, 1999. Article 324. Crimes involving destruction. Any person who shall cause destruction by means of explosion, discharge of electric current, inundation, sinking or stranding a vessel, intentional damaging of the engine of said vessel, taking up the rails from a railway track, maliciously changing railway signals for the safety of moving trains, destroying telegraph wires and telegraph posts, or those of any other system, and in general by using any other agency or means of destruction as effective as those above enumerated, shall be punished by reclusion temporal if the commission has endangered the safety of any person. Otherwise, the penalty of prison mayor shall be imposed. PD 1613 repealed Articles 321, 322, 323, 325, 326 of the RPC. Chapter 9. Malicious Mischief. Article 327. Who are liable for malicious mischief? Any person who shall deliberately cause to the property of another any damage not falling within the terms of the next preceding chapter shall be guilty of malicious mischief. Article 328. Special case of malicious mischief. Any person who shall cause damage to obstruct the performance of public functions, or using any poisonous or corrosive substance, or spreading any infection or contagion among cattle, or who causes damage to the property of the National Museum or National Library, or to any archive or registry, whether works, road, promenade, or any other thing used in common by the public, shall be punished. Number 1. By prison correctional in its minimum and medium periods, if the value of the damage caused exceeds 200,000 pesos. Number 2. By arresto mayor, if such value does not exceed the above mentioned amount, but is over 40,000 pesos. And number 3. By arresto menor, if such value does not exceed 40,000 pesos, as amended by RA 10951. Article 329. Other mischiefs. The mischiefs not included in the next preceding article shall be punished by 1. Arresto mayor in its medium and maximum periods if the value of the damage caused exceeds 200,000 pesos. Number 3. By arresto mayor in its minimum and medium periods if such value is over 40,000 pesos but does not exceed 200,000 pesos. And 3. By arresto menor, or a fine of not less than the value of the damage caused and not more than 40,000 pesos if the amount involved does not exceed 40,000 pesos or cannot be estimated. Article 330. Damage and obstruction to means of communication. The penalty of prison correctional in its medium and maximum periods shall be imposed upon any person who shall damage any railway, telegraph, or telephone lines, if the damage shall result in any derailment of cars, collision, or other accident. The penalty of prison mayor shall be imposed, without prejudice to the criminal liability of the offender for the other consequences of his criminal act. For the purpose of the provision of the article, the electric wires, traction cables, signal system, and other things pertaining to railways shall be deemed to constitute an integral part of a railway system. Article 331. Destroying or damaging statues, public monuments, or paintings. Any person who shall destroy or damage statues or any other useful or ornamental public monument shall suffer the penalty of arresto mayor in its medium period to prison correctional in its minimum period. Any person who shall destroy or damage any useful or ornamental painting of a public nature shall suffer the penalty of arresto menor or a fine not exceeding 40,000 pesos, or both, such fine and imprisonment in the discretion of the court. Chapter 10. Exemption from criminal liability in crimes against property. Article 332. Persons exempt from criminal liability. No criminal, but only civil liability shall result from the commission of the crime of theft, swindling, or malicious mischief committed or caused mutually by the following persons: 1. Spouses, ascendants, and descendants, or relatives by affinity in the same line. Number 2. The widowed spouse with respect to the property which belonged to the deceased spouse before the same shall have passed into the possession of another. And 3. Brothers and sisters and brother-in-law and sisters-in-law if living together. The exemption established by this article shall not be applicable to strangers participating in the commission of the crime. Title 11. Crimes against Chastity. Chapter 1. Adultery and concubinage. Article 333. Who are guilty of adultery. Adultery is committed by any married woman who shall have sexual intercourse with a man, not her husband, and by the man who has carnal knowledge of her, knowing her to be married, even if the marriage be subsequently declared void. Adultery shall be punished by prison correctional in its medium and maximum periods. If the person guilty of adultery committed this offense while being abandoned without justification by the offended spouse, The penalty next lower in degree than that provided in the next preceding paragraph shall be imposed. Article 334. Concubinage. Any husband who shall keep a mistress in the conjugal dwelling, or shall have sexual intercourse, under scandalous circumstances, with a woman who is not his wife, or shall cohabit with her in any other place, shall be punished by prison correctional in its minimum and medium periods. The concubine shall suffer the penalty of destierro. Chapter 2. Rape and Acts of Lasciviousness. Article 335 of the Revised Penal Code has been repealed by RA 8353, Anti-Rape Law of 1997, effective October 22, 1997. New provisions on rape are found in Articles 266-A to 266-D of the Revised Penal Code. Article 336, Acts of Lasciviousness. Any person who shall commit any act of lasciviousness upon other persons of either sex, under any of the circumstances mentioned in the preceding article, shall be punished by prison correctional. Chapter 3. Seduction, Corruption of Minors, and White Slave Trade. Article 337. Qualified Seduction. The seduction of a virgin over 12 years and under 18 years of age, committed by any person in public authority, priest, home servant, domestic, guardian, teacher, or any person who, in any capacity, shall be entrusted with the education or custody of the woman seduced, shall be punished by prison correctional in its minimum and medium periods. The penalty next higher in degree shall be imposed upon any person who shall seduce his sister or descendant, whether or not she be a virgin or over 18 years of age. Under the provisions of this chapter, seduction is committed when the offender has carnal knowledge of any of the persons and under the circumstances described herein. Article 338. Simple seduction. The seduction of a woman who is single or a widow of good reputation, over 12 but under 18 years of age, committed by means of deceit, shall be punished by arresto mayor. Article 339. Acts of lasciviousness with the consent of the offended party. The penalty of arresto mayor shall be imposed to punish any other acts of lasciviousness committed by the same persons and under the same circumstances as those provided in Articles 337 and 338. Article 340. Corruption of minors. Any person who shall promote or facilitate the prostitution or corruption of persons under age to satisfy the lust of another shall be punished by prison mayor, and if the culprit is a public officer or employee, including those in government-owned or controlled corporations, he shall also suffer the penalty of temporary absolute disqualification, as amended by BP number 92. Note: under Section 10 of RA number 7610, the penalty of corruption of minors, if the victim is under 12 years of age, shall be graduated 1 degree higher. Article 341. White Slave Trade. The penalty of prison correctional, in its medium and maximum periods, shall be imposed upon any person who, in any manner, or under any pretext, shall engage in the business or shall profit by prostitution or shall enlist the services of any other for the purposes of prostitution, as amended by BP number 186, March 16, 1982. Note: under Section 10 of RA 7610, the penalty for white slavery, if the victim is under 12 years of age, shall be graduated 1 degree higher. Chapter 4. Abduction. Article 342. Forcible abduction. The abduction of any woman against her will and with lewd design shall be punished by reclusion temporal. The same penalty shall be imposed in every case if the female abducted be under 12 years of age. Article 343. Consented abduction. The abduction of a virgin over 12 and under 18 years of age, carried out with her consent and with lewd design, shall be punished by the penalty of prison correctional in its minimum and medium periods. Chapter 5. Provisions relative to the preceding chapters of Title 11. Article 344. Prosecution of the crime of adultery, concubinage, seduction, abduction, rape, and acts of lasciviousness. The crimes of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended spouse. The offended party cannot institute criminal prosecution without including both the guilty parties, if they are both alive, nor in any case if he shall have consented or pardoned the offenders. The offenses of seduction, abduction, rape, asterisk, or acts of lasciviousness shall not be prosecuted except upon a complaint filed by the offended party or her parents, grandparents, or guardian, nor in any case if the offender has been expressly pardoned by the above-mentioned persons, as the case may be. In cases of seduction, abduction, acts of lasciviousness, and rape, the marriage of the offender with the offended party shall extinguish the criminal action or remit the penalty already imposed upon him. The provisions of this paragraph shall also be applicable to the co-principals, accomplices, and accessories after the fact of the above-mentioned crimes. Asterisk. The word rape is deemed deleted in Article 344 because of the reclassification of rape from crime against chastity to crime against person by RA 8353. Article 345. Civil liability of persons guilty of crimes against chastity. Persons guilty of rape, seduction, or abduction shall also be sentenced: 1. To indemnify the offended woman. 2. To acknowledge the offspring, unless the law should prevent him from doing so. 3. In every case, to support the offspring. The adulterer and the concubine, in the case provided for in Article 333 and 334, may also be sentenced in the same proceeding or in a separate civil proceedings to indemnify for damages caused to the offended spouse. Article 346. Liability of ascendants, guardians, teachers, or other persons entrusted with the custody of the offended party. The ascendants, guardians, curators, teachers, and any person who, by abuse of authority or confidential relationships, shall cooperate as accomplices in the perpetration of the crimes embraced in chapters 2nd, 3rd, and 4th of this title, shall be punished as principals. Teachers or other persons in any other capacity entrusted with the education and guidance of youth shall also suffer the penalty of temporary special disqualification in its maximum period to perpetual special disqualification, and a person falling within the terms of this article, and any other person guilty of corruption of minors for the benefit of another, shall be punished by special disqualification from filing the office of guardian. Title 12. Simulation of birth and usurpation of civil status. Crimes against the civil status of person. Chapter 1. Article 347. Simulation of birth, substitution of one child for another, and concealment or abandonment of a legitimate child. The simulation of births and the substitution of one child for another shall be punished by prison mayor and a fine of not exceeding 200,000 pesos. The same penalties shall be imposed upon any person who shall conceal or abandon any legitimate child with intent to cause such child to lose its civil status. And a physician or surgeon or public officer who, in violation of the duties of his profession or office, shall cooperate in the execution of any of the crimes mentioned in the 2 next preceding paragraphs, shall suffer the penalties therein prescribed, and also the penalty of temporary special disqualification. Asterisk CRA 9262 on attempted trafficking in person and RA number 7610 on attempted child trafficking. Article 348. Usurpation of civil status. The penalty of prison mayor shall be imposed upon any person who shall usurp the civil status of another, should he do so for the purpose of defrauding the offended party or his heirs. Otherwise, the penalty of prison correctional in its medium and maximum periods shall be imposed. Chapter 2. Illegal Marriages. Article 349. Bigamy. The penalty of prison major shall be imposed upon any person who shall contract a second or subsequent marriage before the former marriage has been legally dissolved, or before the absent spouse has been declared presumptively dead by means of a judgment rendered in the proper proceedings. Article 350. Marriage contracted against provisions of laws. The penalty of prison correctional in its medium and maximum periods shall be imposed upon any person who, without being included in the provisions of the next preceding article, shall contract marriage, knowing that the requirements of the law have not been complied with, or that the marriage is in disregard of a legal impediment. If either of the contracting parties shall obtain the consent of the other by means of violence, intimidation, or fraud, he shall be punished by the maximum period of the penalty provided in the next preceding paragraph. Articles 351 of the Revised Penal Code on premature marriages was repealed by R.A. 10655, approved on March 13, 2015. Article 352. Performance of illegal marriage ceremony. Priests or ministers of any religious denomination or sect, or civil authorities who shall perform or authorize any illegal marriage ceremony shall be punished in accordance with the provisions of the marriage law. Title 13. Crimes Against Honor. Chapter 1. Libel. Section 1. Definition, forms, and punishment of this crime *. See Admin Circular Number 08/2008, Guidelines in the observance of a rule of preference in the imposition of penalties in libel cases. Article 353. Definition of libel. A libel is a public and malicious imputation of a crime, or of a vice, or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead. Article 354. Requirement for publicity. Every defamatory imputation is presumed to be malicious, even if it be true, if no good intention and justifiable motive for making it is shown, except in the following cases. Number 1. A private communication made by any person to another in the performance of any legal, moral, or social duty, and number 2. A fair and true report made in good faith without any comments or remarks of any judicial, legislative, or other official proceedings which are not of confidential nature, or of any statement, report, or speech delivered in said proceedings, or of any other act performed by public officers in the exercise of their functions. Article 355. Libel by means of writings or similar means *. See Republic Act No. 10175, an act defining cybercrime, providing for the prevention, investigation, suppression, and the imposition of penalties, therefore, and for other purposes, September 12, 2015. A libel committed by means of writing, printing, lithography, engraving, radio, phonography, painting, theatrical exhibition, cinematographic exhibition, or any similar means shall be punished by prison correctional in its minimum and medium periods, or a fine ranging from 40,000 pesos to 1,200,000 pesos, or both, in addition to the civil action which may be brought by the offended party, as amended by R.A. 10951. Article 356. Threatening to publish and offer to prevent such publication for a compensation. The penalty of arresto mayor, or a fine from 40,000 pesos to 400,000 pesos, or both, shall be imposed upon any person who threatens another to publish a libel concerning him, or the parents, spouse, child, or other member of the family of the latter, or upon anyone who shall offer to prevent the publication of such libel for a compensation of money consideration. Article 357. Prohibited publication of acts referred to in the course of official proceedings. The penalty of arresto mayor, or a fine of 40,000 pesos to 200,000 pesos, or both, shall be imposed upon any reporter, editor, or manager of a newspaper, daily, or magazine, who shall publish facts connected with the private life of another and offensive to the honor, virtue, and reputation of said person, even though said publication be made in connection with or under the pretext that it is necessary in the narration of any judicial or administrative proceedings wherein such facts have been mentioned, as amended by R.A. 10951. Article 358. Slander. Oral defamation shall be punished by arresto mayor in its minimum period, to prison correctional in its minimum period, if it is of a serious and insulting nature. Otherwise, the penalty shall be arresto menor, or a fine not exceeding 20,000 pesos, as amended by R.A. 10951. Article 359. Slander by deed. The penalty of arresto mayor in its maximum period, to prison correctional in its minimum period, or a fine ranging from 20,000 pesos to 100,000 pesos, shall be imposed upon any person who shall perform any act not included and punished in this title, which shall cast dishonor, discredit, or contempt upon another person. If said act is not of serious nature, the penalty shall be arresto menor, or a fine not exceeding 20,000 pesos, as amended by R.A. 10951. Section 2. General Provisions. Article 360. Persons responsible. Any person who shall publish, exhibit, or cause the publication or exhibition of any defamation in writing or by similar means shall be responsible for the same. The author or editor of a book or pamphlet, or the editor or business manager of a daily newspaper, magazine, or serial publication shall be responsible for the defamations contained therein to the same extent as if he were the author thereof. The criminal and civil action for damages in cases of written defamations, as provided for in this chapter, shall be filed simultaneously or separately with the court of first instance of the province or city where the libellous article is printed and first published, or where any of the offended parties actually resides at the time of the commission of the offense. Provided, however, that where one of the offended parties is a public officer whose office is in the city of Manila at the time of the commission of the offense, the action shall be filed in the court of first instance of the city of Manila or of the city of province where the libellous article is printed and first published, and in case such public officer does not hold office in the city of Manila, the action shall be filed in the court of first instance of the province or city where he held office at the time of the commission of the offense, or where the libellous article is printed and first published, and in case one of the offended parties is a private individual, the action shall be filed in the court of first instance of the province or city where he actually resides at the time of the commission of the offense, or where the libellous material is printed and first published. Provided further that the civil action shall be filed in the same court where the criminal action is filed, and vice versa. Provided furthermore that the court where the criminal action or civil action for damages is first filed shall acquire jurisdiction to the exclusion of other courts, and provided finally that this amendment shall not apply to cases of written defamations, the civil and or criminal actions for which have been filed in court at the time of the effectivity of this law. Preliminary investigation of criminal action for written defamations as provided for in this chapter shall be conducted by the provincial or city fiscal of the province or city, or by the municipal court of the city or capital of the province where such action may be instituted, in accordance with the provisions of this article. No criminal action for defamation, which consists in the imputation of a crime, which cannot be prosecuted, the official shall be brought except at the instance of any, and upon complaint expressly filed by the offended party, as amended by R.A. number 1289, June 15, 1955, and R.A. number 4363, June 19, 1965. Article 361, Proof of the Truth. In every criminal prosecution for libel, the truth may be given in evidence to the court, and if it appears that the matter charged as libelous is true, and moreover that it was published with good motives and for justifiable ends, the defendant shall be acquitted. Proof of the truth of an imputation of an act or omission not constituting a crime shall not be admitted, unless the imputation shall have been made against government employees with respect to facts related to the discharge of their duties. In such cases, if the defendant proves the truth of the imputation made by him, he shall be acquitted. Article 362. Libellous remarks. Libellous remarks or comments connected with the matter privileged under the provisions of Article 354, if made with malice, shall not exempt the author thereof, nor the editor or managing editor of a newspaper from criminal liability. Chapter 2. Incriminatory machinations. Article 363. Incriminating innocent person. Any person who, by any act not constituting perjury, shall directly incriminate or impute to an innocent person the commission of a crime shall be punished by arresto mayor. Asterisk. See planting of evidence under RA 9165, RA number 100591, and PD 1866. Article 364. Intriguing against honor. The penalty of arresto menor or fine not exceeding 20,000 pesos shall be imposed for any intrigue which has for its principal purpose to blemish the honor or reputation of a person, as amended by RA 10951. Title 14. Quasi-offenses. So, Chapter. Criminal negligence. Article 365. Imprudence and negligence. Any person who, by reckless imprudence, shall commit any act which, had it been intentional, would constitute a grave felony, shall suffer the penalty of arresto mayor in its maximum period, to prison correctional in its medium period. If it would have constituted a less grave felony, the penalty of arresto mayor in its minimum and medium periods shall be imposed. If it would have constituted a light felony, the penalty of arresto menor in its maximum period shall be imposed. Any person who, by simple imprudence or negligence, shall commit an act which would otherwise constitute a grave felony shall suffer the penalty of arresto mayor in its medium and maximum periods. If it would have constituted a less serious felony, the penalty of arresto mayor in its minimum period shall be imposed. When the execution of the act covered by this article shall have only resulted in damage to the property of another, the offender shall be punished by a fine ranging from an amount equal to the value of said damages to 3 times such value, but which shall in no case be less than 5,000 pesos. A fine not exceeding 40,000 pesos, and censure shall be imposed upon any person who by simple imprudence or negligence shall cause some wrong which, if done maliciously, would have constituted a light felony. In the imposition of these penalties, the court shall exercise their sound discretion without regard to the rules prescribed in Article 64. The provisions contained in this article shall be applicable: 1. When the penalty provided for the offense is equal to or lower than those provided in the first 2 paragraphs of this article, in which case the court shall impose the penalty next lower in degree than that which should be imposed in the period which they may deem proper to apply. 2. When, by imprudence or negligence and with violation of the automobile law, the death of a person shall be caused, in which case the defendant shall be punished by prison correctional in its medium and maximum periods. Reckless imprudence consists in voluntarily, but without malice, doing or failing to do an act from which material damage results from reason of inexcusable lack of precaution on the part of the person performing or failing to perform such act, taking into consideration his employment or occupation, degree of intelligence, physical condition, and other circumstances regarding persons, time, and place. Simple imprudence consists in the lack of precaution displayed in those cases in which the damage impending to be caused is not immediate, nor the danger clearly manifest. The penalty next higher in degree to those provided for in this article shall be imposed upon the offender who fails to lend on the spot to the injured parties such help as may be in his hands to give, as amended by R.A. 10951, August 29, 2017 asterisk. CRA 10586, otherwise known as the Anti-Drunk and Drug Driving Act of 2013. Title 15, Final Provisions, Article 366. Application of laws enacted prior to this code, without prejudice to the provisions contained in Article 22 of this code. Felonies and misdemeanors committed prior to the date of effectiveness of this code shall be punished in accordance with the code or acts in force at the time of their commission. Article 367, Repealing Clause. Except as provided in the next preceding article, the present Penal Code, the provisional law for the application of its provisions, and Acts numbers 277, 292, 480, 518, 519, 899, 1121, 1438, 1523, 1559, 1692, 754, 1755, 1773, 2030, 2036, 2071, 2041, 2212, 2293, 2298, 2300, 2364, 2549, 2557, 2595, 2609, 2712, 2718, 3104, 3195, 3244, 3298, 3309, 3313, 3397, 3559, and 3586 are hereby repealed. The provisions of the acts which are mentioned here under are also repealed, namely Act 666, Sections 6 and 18, Act 1508, Sections 9, 10, 11, and 12, Act 1524, Section 4, Act 1533, Sections 1, 2, and 6, Act 1697, Section 3 and 4, Act 1757, Section 1, 2, 3, 4, 5, 6, 7, First Clause, 11 and 12, Act 2381, Section 2, 3, 4, 5, 6, 8, and 9, Act 2711, Sections 102, 2670, 2671, and 2672, Act 3247, Sections 1, 2, 3, 5, and General Orders Number 58, Series of 1900, Section 106, and all laws and part of laws which are contrary to the provisions of this code are hereby repealed. Approved December 8, 1930. Title of Acts repealed by the Revised Penal Code are Act Number 227, Law on Libel and Threats to Publish Libel, now covered by Articles 253 to 362. Act Number 292, amended by Act 1692, Law defining and penalizing the crimes of treason, insurrection, sedition, now covered by Articles 114, 116, and Article 134 to 142. Act Number 480, Law governing cockfighting and cockpits, now covered by Article 199 and special laws. Act Number 518, amended by Acts Number 112, 1 and 2036, law defining and penalizing highway robbery and brigandage, now covered by Articles 306 to 307, and special laws. Act number 519, Law on Vagrancy, now covered by Article 202. Act number 666, Sections 6 and 18, Law on Trademarks and Trade Names, now covered by Articles 188 to 189. Act number 899, Law regarding suspension of sentence upon U.S. citizens. Act 1438 with Amendatory Act number 3203, 3309, and 3559, provisions governing juvenile offenders and delinquent children, their care and custody, now embodied in Article 80. Act number 1508, Sections 9, 10, 11, and 12, the chattel mortgage law, its violations are now penalized by Article 319. Act number 1523, law prohibiting importation, sale of lottery tickets and lottery, now covered by Articles 195 to 196. Act number 1524, Section 4, law governing discretion of Government General in granting conditional pardon, now covered by Article 159.